This presentation is brought to you by Denied Truth and deals with courts operating outside their legal requirements or their legal obligations to the Queen's subjects. It will also cover your rights within the Ontario Court. The information presented here is by no means extensive. This is a brief overview to allow the viewer to exercise their rights and assert their rights within court. The monarch is the foundation of our current government, and we see from the current slide that there's a coat of arms on the middle of the photograph presented. This happens to be the foundational principle of our current legal system. If we look at a courtroom, in all courtrooms that are operating under the British realm, you will see a coat of arms. The only place that you will not see a coat of arms is in London, because it has its own separate legal system. However, in all courts in Canada and in the UK and in Australia and many other places around the world, you will note this coat of arms. When you see a court official bowing to the coat of arms, they're not bowing to the judge. They're bowing to the protection that is supposed to be afforded to the subjects, the Queen's subjects, within the court. This does not happen in many situations, and this presentation will help you reassert your rights. The Act of Will and Mar was the dispensing of the old legal system and the development of the new legal system. If we read the paperwork here, under the first big paragraph, it said the Lords Spiritual, Temporal, and Commons conveyed at Westminster. Well, the Lords Spiritual and Temporal is an agreement between three different parties, and when it says Temporal and Commons, that represents the House of Commons. So the creation of government was done by Parliament, which is not Parliament. Parliament is in fact the monarch. What they did secondary was they created a Bill of Rights, still done under the Act of Will and Mar and still in 1688. And it says the subject's rights. If we read the first paragraph, it tells you they're supposed to be asserting your ancient rights and liberties. It also says that the levying of money, on the second last paragraph, for use by the Crown by pretense without the grant of Parliament for a longer time than is necessary is illegal. When the court operates and says they have Crown immunity or some sort of legal immunity, that is incorrect, because all the acts within all the courts have to receive royal assent and have to be given permission by Parliament. This is what's meant by royal assent. It is my understanding that any act which happened after 1705 or something in that nature has not received royal assent, and as such all current acts and statutes are in fact unlawful or illegal. If we read the second and third paragraph, they are basically dispensing with the old system and providing the Queen's subjects certain rights and liberties. It says that the freedom of speech, which is also being trampled on us, is also not lawful. The Coronation Oath Act of 1688 established a framework so that everyone that's operating as an extension of the Crown, or of the British monarch if we want to look at it that way, is to take a coronation oath. The police do it, all legal officials that operate within the court basically do it, all court officers, meaning the prosecutors and the solicitors and the legal people, they all take this oath. So therefore we can rely on that oath, or at least try to assert our rights under that oath, for them to follow the law and protect our rights. And it says right here, the oath is to be administered by all future kings and queens. So therefore, if somebody that's the head of the monarch dies, and they appoint somebody new, they have to take the same oath. The Act of Settlement goes further to reaffirm that the government is supposed to administer the acts and statutes, although they may be ratified, with the same protection of rights and liberties of the people. As it says in the second paragraph, the laws of the statutes of this realm for securing the established religion and rights and liberties of the people thereof, and all other laws and statutes of the same now in force may be ratified and confirmed by the same His Majesty, and with the advice and consent of lords spiritual and temporal and commons. So therefore they're telling you that all statutes or acts must receive this royal assent. It also says on the top paragraph, which is the most important, the birthright of the people, and all kings and queens who shall ascend the throne of this realm ought to administer the government of the same, according to the said laws of their offices, and ministers ought to serve them respectively according to the same. So they're telling you right there, any minister or any member that operates within the government is supposed to protect your rights and liberties. Now, they even went so far as the demise of the Crown Act, which states if somebody that's a king or queen, head of the monarch, is to pass away, they have 60 days or 6 months to basically put somebody new in charge. So even if somebody asserts that this is an old law or an old act, therefore it's inadmissible, that's incorrect. The acts I've covered up to now are primary legislation and cannot be changed. Now, if we deal specifically with Ontario, are court cases to be held in public? And the answer is yes. Under Section 135 of the Courts of Justice Act, it clearly says that they're supposed to be held in public. There would only be certain exceptions to this, and that's if the hearing was to divulge issues of national security, or if it was going to expose intellectual property, which in most cases is not the case, and therefore all these court cases which are being conducted under Zoom or some other similar platform, in fact, are all void and illegal, because they're not following the Courts of Justice Act, which is the very regulation which is supposed to regulate the court. I would further ask a question as to why are these court cases being held in private as opposed to public? The COVID pandemic is long gone and was never really an issue in the first place, has been proven. Can you record your own court case? Yes, under Section 136(2)(b) of the Courts of Justice Act, it gives every citizen of Ontario, or their solicitor or anyone acting on their behalf, the right to record their own hearing for the purpose of supplementing their notes. I should draw it to your attention that I requested court audio file, which is supposed to be provided within 30 days, and it took over 7 months, and I had to threaten legal action against the court and the court officials in order to get them to release the audio file, which they previously stated they did not record. All court cases are to be recorded. So what were they hiding? And in fact, when I got the audio recording back, it was not complete. They had taken pieces out of it in order to protect the wrongdoing of the various court officials which were involved in that case. Here we see under Section 136 the fact that you are allowed to in fact take an audio recording of your own transcript or your own court case for supplementing your notes. I also requested documents from the court which I had filed in the court, and I wanted those documents back to prove that they had actually been stamped by the court and accepted, and the court told me I would require a court order to get this paperwork. This is in the Superior Court. This is incorrect, because the court is supposed to be public, and under Section 137, documents public, on payment of a prescribed fee, a person is entitled to see any document filed within a civil proceeding in court. And then it says under 137 sub 4, on payment of a prescribed fee, the person is entitled to a copy of the document. So considering the fact that I required basically 2 pages from 5 different documents, 20 pages in total, I certainly did not require a court order or judgment from a court in order to have them release the paperwork. Again, I ask the question, what is the court trying to hide? I've also had a court case in Toronto sealed by one of the judges, and there is no lawful or legal reason to do so, because there's only certain situations where a court case can be sealed. This would include cases which would divulge information regarding national security, or it would divulge intellectual property rights, or it would expose somebody that is a young offender or somebody in the witness protection program, or expose a family member to identity exposure, which in family cases is not permitted. In all other cases, for the most part, the court is not permitted to seal a case. However, in the Toronto case, the case was sealed at the request of the city solicitor, which is in fact unlawful, and the court cases are presented here. The court is also not permitted to limit your time to a response. If you are a defendant or a plaintiff and you are trying to assert your case, you are allowed to present any and all evidence which you feel is relevant to your claim or your defense. In the Toronto case, the defendant did not file a statement of defense correctly, and the judge permitted it anyway, which means there is now fraud on the court. And also, if a court tries to limit your submissions to a certain time frame, which is unlawful and illegal, they are depriving you of due process of the law, and as such, the court case is void. When fraud on the court occurs, especially by an officer of the court loses jurisdiction permanently. You are not obligated to follow a fraudulent court. Also, many times in court there is information which is relayed from some party who states that they were told by another party some information. This is not directly cross-examinable, and therefore is hearsay evidence. Now, if you can prove that the source of that information is non-credible, in other words, they've told lies, committed an act of perjury, then you can tell the judge or ask the judge to disregard the statements made by the person in court testifying, as they are relying on a non-credible or uncredible witness. And since you can't cross-examine that witness, you request that the information be withdrawn. This is particularly useful because in a certain municipal case that I had to deal with, the party, who was an employee of the city, made many false statements, and therefore if the lawyer was to present that in court, they're relying on an unreliable witness. Now, it so happens that in that same case, the lawyer had also committed many acts of perjury, and this is not permitted. Perjury is never allowed in court, and court cases are to be done under oath, which means you're obligated to tell the truth. If a person makes false statements knowingly, trying to mislead the court or misdirect the court, that is fraud on the court, and is an act of perjury. Under Section 132 of the Criminal Code of Canada, everyone who commits perjury is guilty of an indictable offense and liable to imprisonment for a term not exceeding 14 years. As it states here, when you knowingly falsify information or withhold specific information or convey facts which are not entirely facts, they've been altered or twisted to a certain extent, that is in fact an act of perjury. Keep this in mind. lawyers are not above bending the truth if it suits their pocketbook. This information is a brief overview of your legal rights and your legal authority under primary legislation. You can do further research by contacting the Telegram group listed here, or if you require additional assistance, you can reach us at deniedtruth@yahoo.com. With respect to the Telegram group, it is being set up and separated by specific areas so that people with specific issues can contact people of like mind who are dealing with similar situations based on the same legislation. This group will expand as the need dictates and is based on participation by the people who join the group. I hope that the information presented here is useful, and I hope it is of some benefit to our viewers. And even if it does not apply specifically to your situation, the primary legislation applies to all subjects that are subjects to the realm of the Queen or the monarch. So it would apply in Ontario, it would apply in all of Canada, it would apply in the UK, it would apply in Australia, and many other places. There is a separate presentation which covers the introduction of the Telegram group. It will show you where this specific laws apply. There are also additional seminars and presentations which deal with council tax, property standards issues within the province of Ontario, and the legal court requirements to present a case in court, as well as the ULEZ 15-minute city C40 agenda, and many other topics. So I hope you found this information useful, and I look forward to providing you with further content in the future. Thank you for your time.